Good morning and welcome to this edition of Business Swansea's Power Hour on the subject of employment rights reform and in particular unfair dismissal. The session is brought to you by the UK Local Growth Fund. So we're very, very fortunate to have Mr. Paul Shuttleworth with us this morning, Head of Employment at CJCH Solicitors, offices across South Wales. Paul is excellently placed to be able to keep us up to date on changes to employment law and when we're going to feel the impact of those changes in our businesses. So, Paul, thank you for joining us once more. Over to you. The floor is yours.
Thanks very much. Thanks, Ed, and thanks, Steve, again for the opportunity to participate. And thanks to all attendees, everybody that's logged in this morning for the presentation. Just a quick bit of background as to who I am and the type of work that I deal with. Ed just touched on that briefly, but I head up the employment law team here at CJCH Solicitors. Team is based in Swansea. We're on Water Road, shortly expanding out to a further commercial office, which will be just outside the town, out towards Llansamlet. But based on Water Road at the moment, deal with employment, HR issues, problems, 25 years plus experience really of dealing with commercial and business law issues. And for the last 15 years plus, I've specialised in employment and HR advice, and that's non-contentious and contentious work. So non-contentious work, drafting of contracts, policies, procedures, general HR advice, and the contentious work then essentially anything that's related to a dispute. So that could be internal grievances, disciplinaries, and tribunal work as well. I also lecture on the employment law undergraduate module of the LLB course, the law degree course at Swansea Uni, and I've done that for the past 4 years. So firmly steeped in employment law and advise, as I say, employment HR issues, and that covers really clients from a sort of one-man band, sole traders, up to national, international clients as well. So it's a bit of point of history as far as I'm concerned. The presentation today focuses on changes that are coming as of 1st January next year, introduced by the Employment Rights Act 2025. Significant changes, certainly as far as the two areas I'll focus on, which I think Ed touched on there in relation to qualifying periods, qualifying service for unfair dismissal claims, and also in relation to the removal of the statutory cap on compensation that can be awarded at tribunal. So two areas of focus and very significant changes as far as legislation is concerned. Significant impacts for businesses, I think, from that point forward, and impacts, I think, and changes which businesses should be preparing for now. The impact really should be felt now because, and as I'll explain as we work through, once we get past that 1st January tipping point next year, then the significant changes will be implemented. And as far as the change in qualifying service for unfair dismissal claims is concerned, that changed in April 2012. Previously, it was a year's qualifying service, so you had to be employed for a year continuously in order to be able to bring that type of claim. Changed in April 2012, that was increased to 2 years. So that 2-year period has been with us for 14 years and is now changing and it is being significantly reduced. So that's a huge change and a very significant change in employment legislation and for employment lawyers and for businesses. So that's the overview of what we'll look at, or what I'll look at today. First slide then sets that out. So 1st January 2027. As I said, the qualifying period for protection against unfair dismissal is reduced from 2 years to 6 months. So what does that mean broadly? means that employees who've worked for 6 months continuously, either at that point or after that point, will, if employment is terminated, be able to bring claims for unfair dismissal. As we stand, there's a 2-year period, which you might be aware of, from 1st of January, significantly reduced to 6 months. So again, if the employee is dismissed, date of termination is on or after the 1st January 2027, and they have that 6 months continuous service, they'll have the right to bring a claim of unfair dismissal at tribunal if their employment's terminated and they feel aggrieved and they feel that they should challenge. Then from 1st of January, 6 months is the qualifying period. So why is that important now? You know, we might look at that and think, well, that's a way off. That's next year. I've got other things to be planning for. You know, we can put that off until that time because we've got the best part of 6-7 months to consider and deal with that. But the important thing to consider, and as I've set out in that 3rd paragraph there in my notes, is that if you're recruiting from here on in, then you need to start preparing, because staff that you recruit now, individuals you take on now, if they're working past the 1st of January, then they will have that protection from unfair dismissal at that point in time. Okay, so what does that mean? Well, I think as far as businesses are concerned now, and recruiting now and planning now, the decisions you make on recruitment now clearly matter. You need to be looking at your probation processes, probation periods, procedures, contracts of employment, because they will now be extremely important. And I'll explain further as we work through it as to why that is. But also maybe to look at your onboarding processes as well, to ensure that as far as you can, individuals you're taking on at this stage are a good fit or are the right fit. Because whereas previously, as we stand now, you'd have had 2 years to make that decision and decide whether an individual was suitable or not, was a good fit or not. From the 1st of January, that becomes a lot more compressed. You've only got 6 months then to decide to deal with that and to deal with exiting individuals if needs be, because again, once you get past that point, they have protection. They've got protection from unfair dismissal, and if terminated, then as we said earlier on, potentially could bring claims to tribunal. So even at this stage, onboarding is important, and perhaps more focus on, as I said, ensuring that those individuals that you're recruiting at this stage are a good fit, or as sure as you can be at this stage that they are a good fit and a good fit for the business. So the big shift, and I've touched on some of this as we just worked through there, but as I say, for years, employers have relied on that 2-year qualifying period. And again, that change came in April 2012. So for the last 14, 15 years, there's been that extended period where within 2 years, you can decide, yeah, okay, you know, that maybe this individual isn't particularly a good fit for the business, or they need to improve, and we need to put steps in to bring them through and make sure they're up to speed or where they need to be with us. And if not, we've still got a significant buffer, which within that 2-year period, as the law stands, you could call those individuals in and say, okay, this isn't working, we'll pay your notice, we'll pay your holiday pay, we're terminating your employment. So there was a long period, there was a significant period of time within which you could make those decisions. Now, from the 1st of January 2027, that becomes a lot more focused, that becomes a lot more compressed. And I think the 2-year qualifying period as we stand led to, as I said, their informal approaches being made or being implemented during that time. Maybe things being dealt with informal chats, not being documented, maybe those decisions as to, is this employee in fact a good fit, or do we now need to look at terminating and moving them on? Those decisions may be being kicked down the road for a period because we've got 2 years to deal with it, so we can put that off for a period. And also those easy exits that I touched on there during probation periods, where perhaps you could simply call the individual in, arrange that meeting and say, okay, this isn't working. I said earlier, here's your notice pay, here's your holiday pay, we'll terminate it on that basis. This new legislation fundamentally changes that position, fundamentally changes that landscape. From 1st of January, employees have significantly more protection. And what comes with that, as with any form of protection, is if claims are brought, the employment tribunal will be closely scrutinising the employer's processes and procedures. What led to that termination? Why? What meetings were there? Where's the paper trail? Show us how you arrived at that decision at that point in time. Increased litigation risk. It's interesting, and I was touching on this with Ed and Steve just before we clocked on there, but I was looking at some stats this morning in relation to potential claims, and there's been ongoing government consultation in this respect. But the latest thinking is that reduction of the qualifying period will give protection to a further 6.3 million employees from unfair dismissal. That consultation predicts that will generate an additional 9,000 early ACAS conciliation applications. So if you've been through that process, if you're unlucky enough to have been in that position, perhaps up to now, the way the lead up to an employment tribunal claim works is the individual, the employee, the former employee, has to contact ACAS to start what's called early conciliation. ACAS will take some details. ACAS then get in touch with the employer and say, Joe Bloggs has been in touch, tells us he's been unfairly dismissed. Do you want to conciliate? Do you want to make an offer to settle at this stage? If so, that's what we're here for. If not, the ACAS representative will then go back to the employee, give them a certificate number, and they can go on then to present a claim to tribunal. So the estimate is an additional 9,000 of those early referrals to ACAS, and in respect of which the research estimates there'll be an additional 3,000 claims to employment tribunal. Now, the issue with that at the moment is the employment tribunal claims are severely overburdened. And again, I'd sort of touched on this earlier as the sort of lead into the presentation. But as it stands, correspondence with the tribunal, if I send an email to the tribunal today, I probably wouldn't anticipate getting a response back for maybe 8 to 12 weeks. And I've also seen suggestions recently that claims issued now probably will be still waiting for a final hearing or a trial at tribunal for maybe 3 to 4 years. So the tribunals are massively overburdened at the moment, and this will only increase that burden. And as far as that's concerned, for businesses, if you're a party to that litigation, if you're involved in a tribunal process, then what does that mean? It means more time, more stress, more devotion of your time to dealing with lawyers like me who are asking you to provide documents, to provide witness statements, to provide time and input into the tribunal process, where you'd much rather, I'm sure, be devoting that time to running the business and developing the business. And also the cost as well, because additional time means additional cost in the work that lawyers do in presenting cases and representing you. So, the changes have significant implications and ramifications, certainly as far as recruitment, probation periods, and management of a concerned, but that extends further then into that litigation risk and that litigation cost because of those factors I've just touched on. So again, significant changes, significant ramifications, significant implications for you as business owners, and also then higher compensation exposure. I'll touch on that towards the end of the presentation in relation to changes that are being made to what's known as the statutory cap on compensation for employment tribunal claims, but I'll explain that slightly more fully as we work through. So again, why summer 2026 is a key trigger point, because that's when the unfair dismissal reforms take effect. Again, I'm sort of majoring on this point, but it is important. Recruiting now, then you should be reviewing risk exposure. So what should we be doing at this time as far as businesses, advisors are concerned? Well, you need to be reviewing your contracts of employment, looking in particular at probation clauses, because if you have a probation clause that potentially is 6 months or more, that clearly needs to be revised, because as of next year, you're not giving yourself a buffer if you have that 6-month probation provision. So what we're recommending at the moment is if you have that type of provision in contracts of employment, you scale it back. You maybe have a 3-4 month probation period. So that then gives you a buffer within that 6-month protection period to decide, is this working? Is it not? Do we need to extend? How long do we need to extend it for? Also then, are you documenting fully and properly concerns that you might have with individuals' conduct or capability? Are they being properly recorded from day one of employment? And this is key, really, certainly in relation to employment tribunal litigation, because if you're in that position, if you dismiss, the dismissal's challenged, and you come along to tribunal and give evidence and say, well, look, we had issues with conduct, you know, there were various points at which we had to speak to this individual formally, or capability issues, that they weren't hitting targets, they weren't hitting KPIs, this had gone on for a period, and we came to a point where we decided, actually, we can't continue like this and we have to dismiss. The tribunal, the judge will say, okay, that's all well and good, show me the paper trail. And if you haven't got a paper trail, you're in a difficult position. You know, that position of, well, we did, and the individual was aware of it, and we spoke to them, but it wasn't formalized, or, you know, we don't have a formal paper trail to that extent. That's always a very, very difficult starting position, because of course the individual bringing the claim will simply say, well, I wasn't aware, you know, I thought everything was going swimmingly until the point where they terminated my employment. So I always advise clients, paper trail is king. And yeah, this maybe then feeds into the next point about managers being trained appropriately. Make sure individuals that are dealing with probation reviews are fully across your processes, are fully across your procedures, are following them to the letter, that they're recording meetings, and also that timelines are being hit. Again, coming back to the 2-year position where we are now, you see maybe the tendency in lots of cases to, I think as I said earlier, maybe push out difficult conversations, or, you know, a probation review is set for next Monday, so-and-so's not available. Okay, that's fine. What we'll do is we'll reconvene. We'll get that back in the diaries at some further point in time. Doesn't happen, is left adrift, probation periods pass, issues aren't dealt with. Yeah, it's crucial now that procedures are followed, processes are tightened up on, timelines are met, and that, those conversations aren't left adrift, or if there are difficult conversations to be had, they aren't put off because managers don't want to deal with them or don't want to be put in that position. It's really crucial now, given the reduction in that time frame for protection, that those processes and procedures are tightened up, and that managers who are put in place to deal with them are aware we have to follow process, you have to be across it, and if you're diarising meetings, if you're arranging meetings, they have to take place, and if they don't, then they need to be reconvened quickly, and whatever's discussed is recorded, kept on personnel files, kept in our systems, so that in the event potentially that we are challenged at some point in the future, we can present that documentation and say, this is what we did, this is why we did it, this is what our procedure looks like, and we followed it to the letter. Yeah. And that feeds into the final point then. Could processes at the moment survive that tribunal scrutiny? In the unfortunate event that you are challenged, that a claim is brought, and you sit before the judge and the panel, or your HR manager sits before the judge and the panel, and the judge says, okay, take me through your process, take me through your procedure, show me the documentary timeline. Can we produce that? Can we evidence what we've done? So absolutely key. Paper trails, key. Training, procedural awareness, process awareness for managers, absolutely crucial as well. So the new battleground as of next year, as of 1st January, feeds into some of what I've said earlier. At present, there may be weak probation clauses, poor review processes. Again, I make the point there, make sure dates are diarised and that they're hit. And if they're not, there's an explanation as to why not, and that they reconvened, those meetings of probationary meetings. Again, conduct capability meetings, anything of that kind aren't left adrift. You pin them down, and if the original or the initial date can't be met for whatever reason, they're reconvened pretty quickly. Structured documentation, touched on that. Paper trail, keep banging on that point, but it is exceptionally important. Make sure you have a paper trail, make sure you have a document trail. Managers avoiding difficult conversations. What does that mean? Well, that means, I think, having the right people in place to deal with those types of meetings, those types of conversations. And if you're not entirely sure that the people or the person that you have dealing with those conversations is the right individual to be dealing with them, then look at training, or maybe do you need to bring somebody else in to have those conversations? Because again, those types of meetings, those types of scenarios aren't for everybody, but you need to be sure that the person that you have in place to deal with them is, I guess, suitably robust. The other point with that as well is, which sometimes puts managers off, is that, for those meetings, if in the event of an employment tribunal claim there was a challenge, it might be that manager would be called as a witness and would have to get in the witness box and give evidence as well. So very often you have to sort of think that much further forward as well, to the extent that, okay, if we were put in that position, and if we were challenged and we had to have this person as a witness at a trial, again, would they be suitably robust to be able to deal with that process and to be able to put forward the business position and to be able to explain it clearly and to be able to explain their understanding of policy procedure that was in place and how they implemented it. So again, all considerations when we're looking at onboarding, when we're looking at management of these processes going forward. No clear extension provisions. This is a classic one. Come across this a lot, where probation periods are either missed, the trigger date is missed and the meeting doesn't take place. So the individual is then saying, well, I wasn't sure whether I passed probation or not, or I assumed that I had because we never had a meeting at the 3-6 month point. Also, to make it clear within those probation provisions, within contracts or within procedures, that you can extend if you need to, what period that extension will cover, and what happens at the end of that period. And as I've said, obviously as of 1st of January next year, those periods and potentially any extension of, you need to be building yourself in a buffer so that you're dealing with that before you're hitting that 6-month trigger. So again, coming back to policies and procedures that you might have in place now, contracts of employment, probation provisions, to look at that, to look at those, to make sure you give yourself a buffer. And again, also within that, that maybe you give yourself a bit more room as well if in the event you need to extend probation periods for whatever reason. Again, that point at the bottom of the slide, you may know that someone isn't right, but lack evidence or process to safely exit them later. Keep coming back to the point, put the paper trail. Record, keep records of meetings, keep records of why decisions are made, email trails, because in the event that you are challenged, then, as I say, you'll need to produce them and you'll need to back up your position or substantiate your decision then based on that paper trail that you have. Informal management, touched on this, we contrast there, or I contrast within this slide, maybe that informal position against, again, what a tribunal would expect. That 2-year period, as I've said, quiet chats within the period, informal, non-confrontational, if you like, undocumented, delayed. So-and-so can't attend the probation meeting. Okay, we'll put that off, and it's just left adrift. It's not focused on again. It's not reconvened, and very often that only then becomes an issue once there is a problem. And you then start looking back and saying, well, okay, when did the probation meeting take place, or when were these issues discussed previously about capability or issues about conduct, maybe anything of that kind. And it's only then maybe that you see that there's been a drift and there hasn't been a focus. So again, it's that informal process, which I think the 2-year period at present sort of gives rise to and supports, because that sort of manana view of, okay, we've got plenty of time to deal with this. We've got 2 years, so it can be left for another day. Now we need to focus, and again, the contrast then where, and I've touched on this, the tribunals focus heavily on process, documentation, consistency, fairness. And for an unfair dismissal claim, just as a very brief overview here, if you dismissed an individual, they challenged at employment tribunal, an employment tribunal would look at, and the burden of proof is on you to show that you had a fair reason to dismiss, that you acted reasonably, and that you adopted a fair process. Okay, so the battleground normally comes around, did you act reasonably, did you adopt a fair process? Feeds into those points there. Tribunals heavily focused on process, documentation, consistency, fairness. So these things potentially need to be tightened up in advance of the changes that are forthcoming. Again, recruitment and onboarding and preparing your position, protecting yourself as much as you can at this stage from challenge. Start thinking about this before the employment begins, where you're recruiting, where you're being onboarding. Again, just a summary of those points I've made. Review contracts of employment, review probation clauses, look at job descriptions, look at your performance review systems. You need to be assessing suitability now within maybe the first 3 months. Again, that point I've made of building in a buffer to give yourself room to react within the 6-month period. Look at your onboarding and your line manager training. Are you ensuring that you have the right people in place to deal with these types of processes? So all elements to start thinking about now. Again, 1st of January seems a way off, but the reason for sort of timing this this presentation, this lecture we have, and advice I'm giving to clients generally on this process is, as I say, it's crucial now, because anybody you recruit from here on in, post 1st January gets those protections. So needs to be thought about, needs to be implemented at this point in time. Okay, so that's as much as I had to say on that qualifying period for unfair dismissal being reduced. Significant, needs to be planned for, needs to be planned for now. The other main change then that I've looked at that's coming into place from that point, 1st January next year, is the removal of the cap on compensation for unfair dismissal claims. As we stand, if an employee, a claimant, brings a claim to employment tribunal for unfair dismissal and they're successful, the most they can be awarded in compensation at this stage is either a year's salary or I think it's around about £118,000 at the moment. Okay, so a year's salary is the top end of that scale. From the 1st of January next year, that cap is being removed. Okay, where that's important, I think at this stage, and this feeds into planning and forward looking at this point in time, is that where we are today with the 12-month cap, certainly in relation to senior individuals, is most businesses when exiting senior managers, C-suite individuals at this stage will pitch offers, or settlement offers or termination offers at around about 12 months. So you might be familiar with settlement agreement. So settlement agreement is a tool essentially to cut across the working relationship where the employer and the employee can agree that the employee will exit, and they'll sign off an agreement within which they agree that they won't bring any claims against the employer in relation to their employment and how it was terminated. And in return for that waiver of claims, the employer will pay them an enhanced termination payment. Okay. What we see with senior individuals exiting businesses at the moment, and certainly for the last few years, is that that termination payment, that offer, is normally pitched at around about 12 months. And the reason for that is it takes away the choice for the individual, because the individual generally at that stage has a choice of either I sign the agreement, accept the terms and leave, or I dig my heels in, maybe let them dismiss me and I'll bring a claim for unfair dismissal. Okay. Pitching that offer of compensation at 12 months now takes away the element of choice, because if that individual comes to see me with an agreement and says, this is what I've been offered, I'm not particularly happy, not happy with how I've been treated, you know, I'd quite like my day at tribunal, I want my day in court, my advice is, fine, but you won't do any better than is in the agreement as far as compensation is concerned, and you might pay £10,000 in legal fees to get to that point. So the advice is, if you're being offered a year's salary, you won't do any better, sign the agreement. Okay, so it takes away the element of choice effectively for that individual. And as I've said there, you know, historically, those exits could be handled with certainty, with a relative degree of certainty, in as much as, and to flip that conversation, if you, the employer, were offering that 12-month settlement, then you knew probably that the individual would take that because they aren't going to dig their, or they weren't going to dig their heels in and go for an employment tribunal claim because they weren't going to do any better. But moving forward, that cap will be removed, and that significantly affects that conversation. But what it also does as well within that is it brings in additional elements potentially that that individual that's been exited could then go away and claim, because there's no cap on what they can claim. It's not limited by their earnings. So that means claims moving forward could also include claims for loss of bonus, loss of share allocations, pension contributions. So, you know, these claims now could become significantly more expensive because of the removal of that compensation cap. So what does that mean for us at this stage? Well, a similar consideration to what we looked at with the removal of the unfair dismissal qualifying period. If you as a business at the moment have concerns over capability, conduct of more senior individuals, or maybe if you're looking at those types of individuals and thinking, well, it might be time to look to make this person an offer to move on, or for whatever reason, for succession or bringing other individuals through, you're looking at those working relationships and thinking, okay, what if the working relationship simply isn't working, but there are no real conduct issues that you could latch onto, but it's just a situation where potentially the working relationship was broken down. If you're in those scenarios now, you need to be planning at this stage, because up until the end of the year, the cap's still in place. You've still got that potential for certainty to say, well, look, if we offer this type of figure, which equates to about a year, we're probably going to be able to get a deal done and move them on because the element of choice has been removed. Get past the 1st of January, that becomes a whole different conversation and potentially a hugely more expensive process to exit that person from the business. So again, reference there, documentation. Are you documenting your concerns? Do you have a paper trail? Do you have a process in place? And also, if you're looking at it at this stage, have you financially looked at the cost of exiting the person at this point in time as against the potential cost as of 1st January next year? And also, if you're then drawn into litigation, an employment tribunal claim, the additional cost on top. So that sort of cost benefit analysis at this stage to factor in all those issues. Again, forward planning seems like a way off, but these changes will be coming into sharper focus very quickly. So the commercial reality, broad overview, not just HR issues, not just issues for HR managers, HR directors to deal with. These changes, what's on the horizon, what's happening post 1st of January, pose, say that, potential litigation risks, shortened period for claims, protections being arrived at quicker, financial risks for the business, operational issues, leadership issues, also potential reputational damage as well. That's often something that we factor into discussions around employment tribunal claims or litigation. Are you concerned about the effect that reporting of claims of that kind could have on the business? Employment tribunals are an open forum. Press are free to sit in the days where we'd attend at tribunal in person regularly. Lots done online now, but you'd always get the tribunal in the morning and there'd be Western Mail reporters or Evening Post reporters looking at the tribunal lists, looking at what cases were in for the day, what they're about, whether they're worth reporting. So, there's the reputational risk, the reputational element that you need to prepare for and maybe factor into your decisions as well. But as I say at the foot there, and I know I'm sort of banging on about this point, but those businesses that are preparing now and are putting in place the steps, the processes, the training that need to be put in place, and are also maybe having those thoughts about, well, okay, if there are individuals maybe in senior roles that we feel maybe not a good fit at this point in time, we need to be moving relatively quickly if the sort of line of travel might be that they'll be exited from the business at some point. So prepare now and be in a stronger position as of 1st January. Again, as an overview, immediate priorities: review contracts, audit probation periods, review onboarding, make sure managers are trained. Also look at your disability and capability procedures, whether anything needs to be tweaked within timeframes in those procedures to fit within these new timeframes from early new year, and also assess senior exit risk exposure, which I've just touched on there. You know, if there's anything that's in the pipeline at present that again might be being pushed off for whatever reason, now's the time to focus on it. Now's the time to give yourselves the best opportunity of concluding that deal while there's still that cap in place, which gives you that sort of bookend to pitch your offer at. And that's it as far as the presentation is concerned. I think I'm probably bang on time there, Ed, which is quite unusual. By default, more than practice, I'd say, but just a very broad overview of what we do, and not a pitch it to any degree. But you know, we can help with employment law, health checks. I've been offering that service to clients at the moment to say, look, if you want us to check your employment contracts, if you want us to review your probation periods, we can do that. We can look at where you are now and maybe look at where you need to be, and also then advice on contract review, onboarding, certainly exit strategies, which is a lot of what I do within my practice, exiting senior individuals, and also on the flip side, advising individuals that might be in that position, manager training, and generally that tribunal risk reduction, it falls within the services we offer generally, because as far as advising businesses are concerned, what we're there for is to ensure that you know, you're as protected as you can be, and that we minimize risk as far as we possibly can looking forward. And again, the sort of strap line just at the conclusion there, if you're recruiting now, then this preparation can't wait until 2027, because once you get to that point, employees will have protection, and it becomes a very, very different conversation with significantly more risk attached to exit processes at that point. And that's it. So back over to you, Ed.
That's great. Thank you, Paul. That was really informative, and it's so key for us all to be aware of what's going on. And one thing that really stood out for me there, and I don't know whether I noted it down correctly, but 6.3 million, did you say this will impact?
Yeah, 6.3 additional employees with protection.
Which is, the volume potentially is just phenomenal, and just how bogged down systems and processes and tribunals are going to get. Should a small percentage of that realise itself? So yeah, it's quite the scale of it could be potentially quite phenomenal. So I just want to open it up, if I may. Just obviously, people joining us externally, thank you for doing so. I just wanted to ask if anyone would like to ask any questions of Paul, or have any observations they'd like to. Simon from SCVS, thank you.
So first of all, thanks, Paul. That was really informative. And we support charities and social enterprises, and the reality is, in a lot of those cases that we're talking about, fixed term contracts, usually for a year, that get rolled and renewed if funding becomes available. Is there anything in that kind of short-term contract space that we need to be aware of from the changes that are coming in?
Yeah, I think that the point always with fixed-term contracts is you need to build in a break clause. So you need to build in that provision that says, you know, the contract is fixed for 12 months based on funding, or you know, based on a particular project, but can be terminated on X months notice. Okay. So you build yourself in that protection, because as you probably know, with a pure fixed term, if you like, without a break clause, if you terminate within the period, so if you terminated at 3 months, the individual could then claim the additional 9 months salary on that basis. But you know, for that reason, we'd always, with fixed term contracts, build in that provision that says fixed for 12 months, but we can terminate on 2 months notice should we need to.
Okay, brilliant. Thank you.
Okay.
Thanks, Simon. Steve?
Thanks, Paul. Informative session, as always. We've got a couple of questions, because I'm not really up to speed on this new Employment Rights Act, to be honest. So Has there been any change in the qualifying period for constructive dismissal? Is that still 2 years?
No, that will change as well, because constructive dismissal is a scenario where an individual resigns but claims effectively that they've been dismissed. So that's provided for within the Employment Rights Act 96 legislation. So that will change also, that the qualifying period, because it is technically an unfair dismissal claim.
Yeah,
it'll be the same. Yeah.
Okay. How easy is it now for an ex-employee to bring about a case of unfair dismissal, and is there any financial cost to that employee to bring about that claim up front?
No. And the other thing with that, which is interesting, just very quickly, is that the time frame for presenting a claim to tribunal at the moment is 3 months from the date of termination. That's been increased to 6 months. So there's a longer period of uncertainty for the business, and a longer period within which the individual can decide, maybe I'd like a crack at the business. I haven't found work in the meantime. I'm not earning, so let's have a tilt at a claim. So that's changing as well. But no financial disincentive. There was a fee regime which was introduced maybe more than 10 years ago, I think, where you had to pay an initial fee to register a claim and then a fee to go to trial if you were a claimant. But that was challenged and dispensed with. There's been some talk that might be reintroduced, but I think when it was initially brought in, it was challenged by the unions, and it was then repealed. So yeah, I'm not sure. I don't know whether that will make its way back onto the sort of statute books, as it were. But as it stands, there isn't a financial disincentive, and that's a good question, because it feeds back into the compensation cap being removed. And I think what that might do as well is give encouragement to litigants in person then who are shooting for the stars and thinking, I can bring a claim. It's not going to cost me anything, and compensation's uncapped. So I think that might have a knock-on effect in sort of managing expectations of litigants in person when they're bringing claims.
Final one on a wider point, which is of note, especially to like hospitality businesses. As this new Employment Rights Act bill, is there anything in it with regards to 0-hour contracts?
Yeah, there are changes that will be brought in, which are being looked at, more around sort of guarantees of, or certainty around terms, hours, etc. So yeah, it's something that we're sort of looking at the moment with clients as well, as to how that might be implemented. It's in a sort of bit of a state of flux at the moment, but yeah, there might very well be protections that are incoming as well on that.
Okay, I think I mentioned at the beginning of the presentation that this was part of the UK Local Growth Fund funding aspect of UK government provision. But obviously part of that locally is a growth grant that we provide here at Swansea Council to help businesses that are looking to grow through the provision of a new product or service and connecting that to the creation of full-time employment. So I think that is really important now that grant window is open. Businesses are coming to us for those growth grants to understand that if they're taking on members of staff, obviously this is the environment that we're all now working in, and we all want safe, constructive environments to work in for employees to flourish, but also we want businesses to flourish too as well. So there's a fine line and a balancing point, isn't there? So Paul, thank you. You've touched on some really good preventative measures and obviously some cures as well that we could all be looking at from a business owner's perspective. So really appreciate the time you've spent with us today, imparting that knowledge and bringing us up to speed with that change to the Employment Act. But for now, Paul, thank you once more. Thank you everybody for joining us today, and we'll look forward to seeing you again in the near future. Many thanks. you.